So look to your right and look to your left, and who knows where you'll all be in about 20 years' time. The most important thing, however, is to have a happy and healthy life. And I commend that thought to you, because law is very important, but it's not everything. And what I'm going to do today is to talk about my three favourite dissents. But I have to start by warning you. This is a warning. Trigger warning. It tells you that a dissent is not part of the law, at least at the time the dissent was made. I believe that my former colleague, Justice Gummow, has given you a lecture on how you find the rule in a case. If you don't remember what Justice Gummow has told you, you can have a look at a very important decision called Garcia against the National Australia Bank. There is a passage in my reasoning in that case, which was not in dissent to the orders, which explains how you find the rule in a case. Many people today don't know it, including many barristers and some judges. When I was at law school with Murray Gleeson, David Hodgson, Brian Tamberlin and all the others, Jane Matthews, most of the law we were taught was common law, judge-made law. Judges in Australia, and finally judges of the Privy Council in London. That is how we learned the law. Today, you learn the law mainly from statutes, because there's been a great shift in the time since I was at law school from common law, judge-made law, to statute law. But judge-made law is nonetheless part of the law in some areas where statute has left it alone. And when you try to find what a case stands for, you don't just fumble all around in the place. You immediately look to the end of the case and you see what the judgment was, that is to say, the formal order of the court. And then you go through the judges in the decision who were sitting in the court that gives the decision, and you see what level of the hierarchy they are, and if they're justices of the High Court, they are giving the ruling for and expressing the relevant common law principle. When you're seeking the binding rule, that is to say, part of the law of the land, as strong a part as the statute is, you have to look to the end of the reasons of the judge and see whether the judge was in the majority, that is to say, agreed with the final judgment of the court, or was in a minority. If he or she was in a minority, then it said he or she dissented in the case. And for the purpose of finding the binding rule of the case, you cannot find that in the opinion of a judge in the minority. That judge may agree with parts of the majority or may disagree with parts of the majority and agree with nothing that the majority have written. That does happen. But it's important, therefore, that you face what I have to say today by remembering that I'm going to tell you about three dissenting opinions. First of all, to illustrate this extremely important freedom-giving notion of the English law. This is not the rule in most countries of the world. In most countries of the world, all the judges have to agree in the decision they give. That's called the rule in the civil law cases, countries. But we are a common law country. And virtually from the beginning, the judges of England reserved to themselves the right in a multi-member court to express the majority and the minority if they don't all agree. And that is a freedom-bearing rule, because it means that unlike the civil law, the civilian system, the judges don't have to put their name to a ruling they don't agree with. It's been a very important aspect of our judiciary and of our nation and of the way we live together, that the judges don't have to agree with others and don't have to pretend that they agree. They give their own decision, make their own ruling, and that is a guarantee that you're not just getting a rule that is created by Tammany Hall. You're not getting a rule that is created by high officials called judges who do a deal with each other. Well, you agree with me and I'll agree with you. That doesn't happen. It shouldn't happen. Each judge, you may agree or disagree with them, expresses their sincere opinion, unless in particular cases the judge might sink their own opinion and go along with the majority. That sometimes does happen, and sometimes can be justified in cases of great constitutional moment. But normally the judge has the privilege and the responsibility to express their true decision, and applying the case of Garcia against National Australia Bank, you can be sure that what you see on the papers of the High Court of Australia judgments, they are the true opinion of the judges. It is sometimes a burden to dissent, because that means you've got a right. You can't just send around a little note, which otherwise you might, saying, Kirby J, I agree with the opinion of Gummo J. That doesn't happen if you don't agree. It means you have to explain why you don't agree. And that can be very burdensome, because you've got to be very accurate and you've got to be very careful. And basically, by the time you got to the High Court of Australia, you have to be a very, very experienced lawyer. And your opinions will be judged by professors, by law students, and most critically by your colleagues, because they may reach a different view. And then there'll be polite but firm disagreement which will be expressed in the cases. So that is our system of dissent. Doesn't happen in China, doesn't happen in Japan. Well, it can happen in Japan under the constitution imposed on Japan by the Americans after the Second World War, but it very rarely happens because their tradition is the civilian tradition. It doesn't happen in France, doesn't happen in Germany, but it happens in the English-speaking countries, because that was what the English did, and it's a liberty principle. Now, I'm going to tell you 3 cases, but in the light of what I've just said, they are not an expression of the law, but they're an expression of how I resolved a difference. And that requires that you see what is working here. Why has this judge disagreed? When I was at law school at your stage, maybe a year or so later, there was a very great professor at this law school. He later went to the University of New South Wales at the end of his career, Professor Julius Stone. You have heard about him or will hear about him. He was the professor of international law and the Challis Professor of Jurisprudence. So his position required him to explain, what on earth are we all on about? What is the law we administer? Why is it so? And he was a great writer, very industrious. He used some of his best students to help him on his books. I had that privilege. and I got to know him and to admire him greatly. The theory of the law at the time I was at law school was propounded by Sir Owen Dixon, our great Chief Justice of Australia, before that a very long-serving justice. In those days there was no retiring age for judges, and so he went on for forever. When I was at law school, when I was a young lawyer and well into my career. And he propounded the view that the law would have lost its meaning if a case did not have one correct approach and one correct order. The law for Dixon would have lost its meaning if it was just the opinions of judges. There was a clear rule, and the job of the judges was to find that rule. And once they'd found it and declared it, then that was the only rule, and there was no room for difference, no room for disagreement. Professor Julius Stone, who was affected by Professor Roscoe Pound, the Dean of Law at Harvard, taught what one would call a realist view, that the law is what the judges declare it, and that values greatly influenced what the judges say. And that was different to Dixon. So there was, whilst I was sitting there in law school, there was this mighty battle between two very great lawyers, Sir Owen Dixon, the Chief Justice of the country, and Professor Julius Stone, a senior professor at this law school. And that difference lay at the heart of the role of the judge in decision-making. And I was convinced by Stone's view. I think most people were convinced by Stone's view that judges have what Stone called a leeway for choice, and that where the Constitution was ambiguous, or where a statute was unclear, or where the common law had gaps or was uncertain, the judge has to fill the gaps or resolve the ambiguity, and that is just what judges of the common law tradition do. And that's why we have disagreements, and that exposition of the values is a very important, and from the judge's point of view, very liberating and very important job that they have to try to convince the people who will read their opinions, and particularly if they're in dissent, what they say the law is on the point. So I'm going to give you three very little illustrations. We don't have time to go deeply into the cases, but they are all relatively recent cases in the High Court, and I hope they illustrate to you this conflict between what Sir Owen Dixon was declaring to be the system of the common law and what Julius Stone, my professor, was declaring was the tradition of the common law. Nowadays, I think most people accept Stone's view that judges have to fill gaps, have to resolve ambiguities, and they do that taking into account the history of the law, the language that they're interpreting or elaborating, and necessarily, to some extent, their own values. So that's what I want to teach you today. The first case is a case called Al-Kateb against Godwin. The citation of Al-Kateb and Godwin is 2004, 219 Commonwealth Law Reports, 380. Al-Kateb and Godwin. Mr. Al-Kateb was a person of long-time residence in Kuwait, but he wasn't a Kuwaiti citizen. He was a citizen of Palestine, and he wanted to be accepted in Australia as a refugee. He came on a boat. He went through all the processes that we hurl at people who seek to become admitted as refugees. He lost in all the steps of his legal challenges, and in accordance with the Migration Act, he was taken to detention, which was the duty of a migration officer. If he didn't have a visa, if he didn't win his case and secure a bridging visa or some other form of permission to stay, he was an unlawful non-citizen, and it was the duty of the migration officers to send him straight away to migration detention, and he would stay in migration detention until one of three things happened. The first was if he were granted a visa. The second, if he were granted non-citizen status to remain. And the third was if he elected to leave. And the election to leave required him to send a letter to the minister saying, in effect, I give up. I want you to send me to my country of nationality. But the problem was the country of nationality was Palestine. Australia made many attempts to get the permissions to get him into Palestine. But the government of Israel had a firm policy, they probably still do, that doesn't facilitate and indeed makes virtually impossible getting from Israel into Palestine, and there is no other way effectively to get into Palestine. They think they've got altogether too many Palestinians and they don't want any more, and they won't let them in and they won't give them transit visas. And so there was Mr. Al-Khatib in immigration detention, and unless things changed, he was there forever. That led to him going to the High Court, and a majority of the High Court, led by Justice McHugh, a great judge, said, no, he is a non-citizen and the duty is to send him to immigration detention. It's clear in the Migration Act. Don't argue about this. The language is absolutely plain. But that led to three justices of the court, Chief Justice Gleeson, Justice Gummow and myself, to say that is not and cannot be the law. We disagreed in how we came to that conclusion. The justices, Chief Justice Gleeson and Justice Gummow, said the postulate of the Act is that you will and can send a person, if he gives up, back to his country of nationality. Because Israel does not and will not do that, part of the postulate of the Migration Act was not fulfilled, and it therefore had to be considered and was not the end of the story, and it didn't adequately cover his case. I wrote one of the shortest decisions I ever wrote in the High Court of Australia. I wrote, I agree with Justice Gummow, who had written the first draft. But then I added a few paragraphs, and if you look at Al-Khatib against Godwin in 219 Commonwealth Law Reports, you will see where it happened. You can see the history of this case. Normally you don't get a glimpse of this, but in the structure of my reasons. I began by saying I agree, but I have a few points to add, and I added points by reference to international law, because international law is today a very important part of the world and of the world's legal system. And ever since the Charter of the United Nations, that has been the development of international legal systems. And so I added these little words saying, and I think it is not the legal obligation in the case of Mr. Al-Khatib, because if it were, that would be a most serious breach of the international principles of human rights expressed in UN treaties to which Australia is a party. And international law stands against stateless persons, and therefore Mr. Al-Khatib is not being lawfully detained. And so Chief Justice Gleeson and Justice Gummow dissented. They dissented on their interpretation of the Act. I dissented, and I agree with their analysis of the interpretation of the Act, but I added this extra element. And that then led to Justice McHugh claiming that this is not part of the law, and ultimately asserting Justice Kirby is here guilty of heresy. And that led to me thinking, I'd never give anybody a free kick. And so I began to respond. And Justice McHugh responded to me, and I responded to him, and he responded to me. My associate at that time was a young lawyer from Perth, the University of Western Australia. She's now a professor of law at Columbia University in New York. She is a seriously clever professor and woman, because it was always my policy to take one male and one female in my associates. And Sarah Nucky said she never knew a more exciting time than when we were deciding Al-Khatib and Godwin, because in would come Justice McHugh, and then out would go mine. And she said, I was really surprised and intrigued to see the way you would write out your response, and then Justice McHugh's response would come back within a matter of hours, and then mine, and then his. So read Al-Khatib and Godwin. It's an interesting story and an interesting record, and a very important case about the interrelationship of Australian law with United Nations treaty law, and our obligation as a membership country and as a signatory and ratifier of the treaties to conform to what we had accepted and promised to conform with. You can disagree about these issues. Myself, I think the reasoning of Chief Justice Gleeson and Justice Gummow is very compelling, but it didn't gather the fore. When I first arrived, Justice McHugh told me, Kirby, there's only one thing you've got to know about this court: four, because the four is the majority. And if you've got the four, you've won the case, and you can write the decision and make the rule as part of the majority, and you know then that that is the binding rule of Australian law. So that's case number one. Case number two is a case in an area of the law that I knew a lot about, because most of the people who get appointed to the High Court of Australia have been, into recent years, people whose whole life has been dealing with commercial disputes, law of contract, law of trade practices, and other areas of the law. My area of the law was substantially in industrial relations law, trade union law, and the law of industrial relations. And that meant I was constantly before the Industrial Relations Commission of New South Wales and the Federal Arbitration Commission, to which I was later appointed in my first judicial posting. And that meant I knew quite a lot about industrial relations law. And the second case is the work choices case. This was a case that followed a decision of the Howard government to completely change 110 years of Australian law relating to industrial relations. The work choices case is 2006 229 CLR 1. And the Howard government said, we're not going to use the arbitration power. We're going to use the corporation's power. And the corporation's power doesn't have the restrictions that the arbitration power has. Anybody who practiced in the area of industrial relations or work law knew off by heart the language of section 5135. The covering words of the section were the Parliament shall have power to make laws for the peace, order and good government of the Commonwealth with respect to 35. Conciliation and arbitration for the prevention and settlement of industrial disputes extending beyond the limits of one state. It was something we copied from New Zealand. New Zealand began inserting conciliation and arbitration to stop the big strikes. And that led to an act in New Zealand in the 1890s to try to stop a very big waterfront strike, which was affecting Australia as well as New Zealand. And so this provision was put in the Constitution. And that provision meant you had tools with which the federal parliament could make a law that permitted the settlement of an industrial dispute, but only if two requirements were met. First, interstateness, that is to say, extending beyond the limits of one state. And second, that it was done not by direct federal legislation, but was done by conciliation and arbitration. And that latter provision was both innovative, it had been considered in more than 100 leading cases in the history of the Commonwealth by the High Court. It was probably, the Tax Act might have been more, but it was an area of statute law that was dealt with all the time. And so you would analyse what the words meant, conciliation and arbitration. That means you have an independent person who decides the matter either by imposing, that's arbitration, or by seeking to secure agreement, that's conciliation. And in some ways, it was a source of pride in Australian law that we had this mechanism that would provide for that form of resolution of big industrial disputes. And then came the work choices case, and in 2006, and that just said, oh, forget about that. We're not going to go down that route. It's so time-consuming, and in any case, we want to not empower the unions who are part of a procedure of conciliation arbitration. We want to ensure that the private sector decides these matters without too much interference. They didn't quite put it that way, but it was part of this big push in the 1990s and 2000s to substitute for government interference and awards by independent bodies the procedure for requiring agreement in work choices in the place of industrial awards. Now the question was, is that a constitutionally valid approach? And the High Court again divided. Justice Callanan, who was probably the most conservative judge on the court in my time, dissented, and I dissented. We basically agreed that you can't use a head of power, the corporation's power, which doesn't have these checks and balances of the arbitration power, and just simply ignore the arbitration power and effectively make it a completely dead letter in the statute. Why should the Parliament impose a law which contains a requirement of conciliation and arbitration if it doesn't have to? Most employers now are corporations. You just go straight to the corporation power, forget the requirement of interstateness, forget the requirement of conciliation, forget the requirement of arbitration, and that's it. That approach had some support in the approach of the High Court of Australia to reconciling where there were two different or three different heads of power that might be invoked. And generally, it was permissible to choose one or the other. But where one of them had provisions that was protective of the rights of people, such as the provision relating to compulsory acquisition of property on just terms, the High Court had said, well, if there's a protective provision, you don't just use another head of power. You can't build a whole system of law on lighthouses because there is a power in respect of lighthouses. You have to, if there's protection, you have to comply with the protection. And so most of the court, that is to say all but Justice Callanan and myself, that is to say 5 justices to 2, decided that the law was valid. But Justice Callanan and I, for different reasons, said, no, if there's a specific provision, you have to comply with that specific provision and not just use another provision to say what you want the law to be. So that was that decision. But at the heart of it was the importance that I expressed was found in those words conciliation and arbitration, which introduced an element of industrial justice to be decided by an independent person, and that had been our system for 110 years in Australia. So we dissented. The third dissent I want to tell you of was actually handed down by me on my very last day of service in the High Court of Australia. There was a big ceremony on for the new silks. There was a huge ceremony on as a farewell to me. And there was the handing down at 2 o'clock of the reasons in a very important case. This is Wurrajul against the Commonwealth. It's a case concerning the constitutional validity of the legislation enacted through Parliament on the proposal of the Howard government for the Northern Territory intervention. You remember the Northern Territory intervention? Empowering the Commonwealth to move into the Northern Territory and to take over people's, Aboriginal people's, land and leaseholds and any other property interest, because it was contended that they're all getting intoxicated, and what they need is a firm hand that will ensure that they can't get any access to alcohol, and also that issues of sexual abuse and family abuse can be dealt with very, very firmly in the case of Aboriginals. And Wurundjeri is, in 2008, 237 Commonwealth Law Reports 1. And that decision saw me in lonely, single dissent. And this is the reason why. One of the grounds for the challenge to the validity of the Northern Territory intervention legislation was that it didn't provide the Aboriginal people from whom property, leaseholds, and in some cases ownership was based. The provision in the Federal Act required that where that was done, the Commonwealth had to give money compensation, and that was just compensation. But there was a difference in our constitution as opposed to the Constitution of the United States, which we copied in many respects. And that was a difference in the language used for compulsory acquisition. In the American Constitution, the provision says that the federal Congress can only make laws for compulsory acquisition on the provision of just compensation. Remember those words, just compensation. But the argument that was put to us by Pamela Tate, QC, the Solicitor General of Victoria, was it is true that the Commonwealth has provided for the payment of just compensation to Aboriginal First Nations people, but it never consulted them. It didn't ask them. It didn't ask to find out if there was a particular need in their case or in cases like theirs. It just barged in and did what so many times we have done in Australia in respect of First Nations people. It just enacted the law. No doubt intending to do something for the benefit, but not troubling to ask those who were affected what they had to say about it. The idea for the intervention arose out of an inquiry into sexual abuse and violence in the Northern Territory against Aboriginal children. But the commissioner who wrote that report said it is very important that the Indigenous people be asked and that they be involved and that they be given an opportunity to have their say. And we've gone beyond in Australia doing things in good intentions, just imposing our will on the Indigenous people. We should ask them, and we should consult them, and we should respect them. So, when it came to my decision in the case, given the uncontested evidence that the Commonwealth had not asked, had not considered, had not requested, had not had public hearings, had simply barged in and imposed its will and provided money, was that just terms? The American provision said just compensation, and it would have conformed to that. But do just terms only mean money, or do they involve a question of whether there has been a proper process of consultation and listening to the voices of those who are affected? Chief Justice Dixon, as a Justice of the High Court, had pointed to this distinction in the language in an earlier case. He'd pointed to the difference of just terms and just compensation. And I simply picked up what Justice Dixon said, and I said, yes, it's true, they've provided for money, but They haven't done this as the Commissioner recommending action had recommended, of close consultation, and there's been too much of this imposition on the Indigenous people, and that making laws that only applied to a particular group by reference to their race was not something that we should continue in Australia, or at least we should not continue unless we have gone to a process of consultation and consideration, as the Commissioner said. So those three cases that I've told you, Al-Kateb, the Palestinian, who was to be locked up forever if nothing changed, the work choices case, the case involving a decision to use the corporation's power instead of the protective industrial justice provisions of subsection 35, and the Wurrajul, the case of the acquisition of property of the Indigenous people in the Northern Territory without any consultation on the basis that that was just terms. They are the three cases that I want to tell you about. Now, in none of them has the view that I expressed been upheld by subsequent decisions. I'm not mortified by this. Do I lose sleep at night? Not at all. Once you've done one case, you move on to the next, and I need my sleep, so I don't worry too much about the fact that I was in a minority. I am proud that I was part of a legal system that permits the judges, and indeed requires the judges, to say their true and honest opinion. You may not think much of the opinion, you may not think much of the judge, but at least you know that under our system, it is that the judges should each state their honest and true opinion. And having a country with uncorrupted judges is relatively rare in our world. When I used to have guests from overseas, from Indonesia and other countries around us, I said, I have never in my 34 years as a judge received a packet containing dollars. I've never had a minister telephone me to say, oh, Judge, the government would like a decision in this matter that favoured the view of the government. I've never gone to a club where somebody from the big end of town has said, wink, wink, nudge, nudge, we'd like to have that decision in our favour. Doesn't happen. But there are other ways that the opinions of the judges can be affected, and that is by appointment of people who've had a particular experience in life and who have values that will be different. During all of the time, or most of the time, I was on the High Court of Australia, I was the only justice whose entire education was in public schools. I went to my old public school, high school, Fort Street High, on Friday last. And I went in the afternoon to a conference of principals of public high schools in Sydney. Hands up in this class, everyone whose entire education has been in public schools. Well, that looks pretty good. It should be 66%, because that's the people who've been educated in public schools. When I went to school just after the Second World War, some of the children came into the class at Strathfield North Public School barefooted. You know, these were times just after the war when there were a lot of very poor people, because we'd made great efforts to win the war. But the fact that I'd met people of different races, of different religions, or of no religion, and of different values, was a very important part in my preparation. And so when you hear, oh, well, Justice Kirby's the great dissenter, you've got to ask, what was he dissenting about? Who was he dissenting against? Because otherwise, you're being very superficial about the importance of values. And that was something Julia Stone taught me, and it's something today that I'm teaching you. That's the end of my address. We may now have a few minutes for questions. Yes, we've got 7 minutes, but first we'll have a big round of applause. Okay. Now, are there any questions or comments? You don't have to agree with what I've said. You're not going to be locked up and suffer the deprivation of your property. You can just have a different point of view, and that's part of our freedom. Does anybody have any questions? Yes.
Thank you for your time today, Mr. Kirby. You're obviously a figure that many law students look up to, and I was just wondering, when you were a student and in your early career, who were the eminent Australians that you looked up to and why?
Well, I looked up to my teachers, who were very important in my life, and one of the teachers at the Summerhill OC class in 1949 was Mr. Gorringe, Keith Gorringe. He'd fought in the Second World War, and he had the badge that all ex-servicemen had. A lot of teachers in public schools had the ex-serviceman badge, and he hated war. He wasn't one of those Australians who gloried in our glorious war. He hated war. And on a certain day at the end of 1948, when I was 8, he gave all of us a copy of the Universal Declaration of Human Rights. This December will be 75 years since the Universal Declaration of Human Rights was adopted. It's therefore a very important moment for me, because it really affected my view of the world. And Mr. Gorringe taught us all boys, because in those days it was separated by gender, he taught us how important it was to learn and digest, think about, and apply in our own lives the Universal Declaration of Human Rights. And I think it would be a good thing in Australia if we didn't have, if we had a system of teaching all the children about the Universal Declaration. We got that copy, little copies, on airmail paper, which itself was very unusual in those days, from the Minister for External Affairs, Dr. H.V. Evatt. Dr. Evatt also went to my high school, and he was a sort of hero that we were taught about. He also, I knew, fought against the legislation introduced by the Menzies government to ban the Communist Party and to impose a whole raft of restrictions on people who happen to believe in communism. You might think it absurd, you might think it an oppressive idea, but the way to fight it in a country like Australia is to fight it in the polls, and the communists never won. I think in Queensland once they won 1 seat, but they didn't win elections. And so Dr. Evatt was a person whom I admire. He fought against the communism case in the High Court, and he won. The High Court of Australia struck down the Communist Party Dissolution Act. And then Mr Menzies took it to the people in a referendum, and the people, by a whisker, but nonetheless by the constitutional majority, said no. That was really a very important moment in Australia's history, because if that had not been no, who knows where the processes of autocracy might have led. And so I had lots of heroes. My parents were heroes. My father was a very good storyteller, and I'm still a pretty good storyteller. And if you read my reasons, you'll see they are comprehensible. Public schools. They are the language of ordinary people. And so my father was a great storyteller, and my mother was very perceptive. So I had great blessings in growing up. And then at the age of 29, when I thought I was being put out to pasture, I met my partner, Johan. And that has been a great blessing in my life. If you've had those things, terrific parents, great and supportive relatives, and a friend and lover who is supportive, you're a very lucky person. And you can cope with the world. Whatever it throws at you, you can cope with it. So, that would be my answer to you. Dr. Everett in public life and my dad in private life. Any other questions? Well, I think I've left you all speechless. There's one up there. I'll come up and... They should have railings on these. Where are you? Yes. I hope you appreciate this effort.
So thanks so much for the lecture and walking up the stairs. I just wanted to ask, so where do you see, like, how do you walk the line between, let's say, the separation of powers and not, like, intruding on Parliament's will to legislate or not rewriting the legislation, and making sure the legislation is, like, updated through the common law system, so like judicial activism, and, like, not making sure it's left as it was in, like, the 1970s?
Well, I think my answer to that is very similar to what Sir Anthony Mason said when he was asked, and when you decided Mabo and when you decided these other cases, were you guilty of judicial activism? He just turned around, swept his hand and said, you see these books? This is what's been done by judges. They've been doing it for 8 centuries. They've been active. The question is not whether a judge should, in a particular case, decide one way. The question is, what is our system? And the reason why, when the British Empire collapsed, the law, the common law, continued was because it's a very practical system. And it's made up of judges, and they will have all sorts of different views and different values. But having that system is a very important check against the thing all just freezing over. Already the judiciary is rather conservative. Most judges, even today, have been educated at school in private and religious schools. But there is variety, and that is the system. And when I'm accused of judicial activism, I just sweep behind and say, where do you think it all came from? It came from activism. The question is not, is there activism, but is there inappropriate activism? Now, was there inappropriate activism in the case of Mr. Al-Khatib? I don't think so. I think it was a judge saying we now live in a world of international law, and so context is important in law, and the international law is part of the present context. Was it activism?